Hello, CL 101 students and scholars. My name is Aaron Swift. I am the CEO and managing partner of Swift Law North, SLN, and Consumer Law 101, or CL 101. Today we are continuing our FCRA lecture video series by discussing permissible purposes. When can someone pull a credit report? All right, in this video, the agenda will be the first thing we're going to do is review the common law foundations of the FCRA because that ties directly into this topic about permissible purposes and the permissible use of credit reports. Then we're going to talk about and discuss the 6 or 7 statutorily itemized permissible purposes. It just depends how you want to group them, if there's 6 or 7, but we're going to talk about them all. And then lastly, like we do with every video lecture, we're going to tie it into the larger issue of litigation-backed credit repair to see how it ties in. All right. So, without getting too far into the legal weeds, most statutes that are created by Congress, especially those that give a private right of action, which means here's a statute and you can sue if someone violates this statute, generally they have to have a foundation in English common law to be constitutional. And we're not going to go into the reasons why. It's very arcane. But suffice it to say that if you have a private right of action, which all of our consumer statutes do, that's why we're using them on this litigation-backed credit repair, because the leverage of suing is so great. And each one of them have some foundation in English common law. Here, the FCRA is founded on the common law principles of invasion of privacy, intrusion upon seclusion, and damage to reputation. And think of it, if someone doesn't have a legal right to look at your credit report, and they do, that's such an invasion of privacy. They're going to find out information about your job, your past jobs, your social security number. I mean, they have no right for that. That's definitely an invasion of privacy. And it's an intrusion upon your seclusion, because you should have the right to feel that your personal information is protected and it's secluded from anyone else. And lastly, if someone credit reports something incorrectly, incompletely, erroneously, falsely, and that information is transmitted to a third party and published, and that harms you, that is a damage to your reputation. And that was definitely a common law claim in history, and now it definitely forms one of the founding principles of the FCRA. So that's kind of the legal background to give you some foundational reasons why, it's so important to understand these definitions and when and where and how people can use credit reports. All right, so I put 7+ here and 6+ on the agenda. Again, it's really the same. In the statute, again, we've harped on this. I will keep harping on this. You go to the definitions. And under the FCRA, it's very clear. The statute itemizes very specific reasons and circumstances that someone can obtain and use a credit report. They are a court order or a subpoena. Those are easy. It's just what it says. If there's a court order for it or a subpoena, then those are generally turned over, sometimes with some restrictions. Number 3 is the big one, the most common, is written instructions or permission from the consumer. That's just like a credit application. I'm guilty as charged. Even though I'm a consumer protection attorney, I don't always read all the fine print, but I know it's in every credit application, every job application, applications to open up checking accounts. That fine print is going to say that you are giving that company, that furnisher, that prospective employer, landlord permission to pull your credit reports. It's in black and white, and that's one of the most common reasons, of course. Here's another one: users for credit, employment, or insurance decision. It's kind of what I just talked about, but even if there aren't written instructions, there are certain types of employment, like in the federal space, sometimes the security space, financial industries, that don't have to give permission. Those types of uses are just automatically covered. Number 5 is huge. A lot of people don't understand this. A lot of consumers, a lot of credit repair companies, and so-called experts just don't understand this. If a debt is turned over for collection, that collector, the debt collecting third-party company, they have the right to access the consumer's credit reports, because debt collection is one of the very specifically enumerated permissible purposes under the statute. That's so important. We hear all the time, oh, they violated the law. I've never heard of this company. I don't have a contract with them. How dare they? They violated the law. We're going to sue them. And I just have to say, sorry, that is a permissible purpose. Now, if it shouldn't have been in collections, that's a whole other story. There still needs to be a reasonable basis for it to be in debt collection. So there are some circumstances where debt collection itself isn't enough because the debt collection may have been illegal in the first place. Number 6 is kind of a catch-all, other reasonable, valid business reasons. And then 7, there's even a couple additional, enumerated things like Homeland Security, IRS, and other government uses. But for us, for CL 101 scholars and students, for credit repair companies, the ones you really want to key in on are basically numbers 3 and 5. When you're looking at the credit inquiry sections, did the consumer give written permission? Did they, apply for credit, apply for a job or insurance with this company? If so, number 3 is going to apply. And if it gets to debt collection, number 5 is going to apply. And again, that's something that's very much misunderstood, and we hear it all the time, even at conferences, that debt collector X, Y, and Z is violating the FCRA because they're pulling consumer credit reports. Sorry, that's not a claim. The statute gives them that permission very specifically. All right, and lastly, like we do with each topic, how does this connect to credit repair, and in particular litigation-backed credit repair? In order to use litigation effectively, to use it to fight back against these unscrupulous companies, you have to have the founding, issues understood. You have to be able to know the definitions. And this is so important. If you go to the statute, we use the inquiry sections a lot in offensive ways and defensive ways. If we find out that companies are impermissibly pulling credit reports, that gives us a lot of leverage. I'll give you an example. After a consumer files a bankruptcy, someone that they discharge that debt, that company doesn't have the right to keep pulling, clients' credit reports every month, like you would have the right for, an accountant review because you've given them that, again, written permission. But after bankruptcy and the discharge, that's gone. So that would be one reason where, someone might be looking at someone's credit report, and we found an offensive way to sue, put some money in the consumer's pockets and ours. It's just so important. And the other thing is the inquiry section really gives us a good snapshot. If a lot of debt collectors are recently looking at inquiries, we know, hey, if there aren't a lot of collections yet on this credit report, they're coming. And sometimes that's going to tell us, slow down. We need to figure out what's next with this consumer. But again, it just always goes back to understand the founding principles. Watch these videos, rewatch these videos. It's going to give you the tools you need to succeed. And those tools are going to lead to debt forgiveness, debt waiver, higher credit scores, and much happier clients. So again, thank you for tuning in. This has been a video on the permissible purposes under the FCRA. For more information, please visit consumerlaw101.com and swiftlawnorth.com. Look forward to seeing you and hopefully more of our webinars, some of our chats, look into our scholar options. And again, just keep watching the videos, learn the tools, and help fight back. Thank you.